I go buy a house that's say $100,000. All right, $50 gold legal. Do you take the $50 value of the gold legal, or do you take the $1,500 value of the gold that's in the gold legal to pay
For simplicity's sake, okay, if you have a $100,000 house, then I tell them that I paid $5,000, which is 100 gold eagle coins with a face value of $50 each, right? And so that's, if you had to go out and buy those things in commercial paper, you'd pay about $150,000, right? But the face value is only $5,000. So I tell them that I only paid $5,000 in lawful money, which is 100 each $50 gold pieces.
Yeah.
You see what I'm saying?
Yeah.
That's $5,000 in lawful money, but if you had to spend it on commercial paper, if you had to go and buy commercial paper with it, it'd be $150,000, and the house is worth $150,000. And you see what I'm saying?
Yeah.
You just use the face value.
Is
what you're
right. Well, of course. I mean, I don't care what the value of commercial paper is, just because it's worthless.
Yeah.
I want to specify that I paid lawful money,
Right.
but I don't want to. That's the equivalent of what anybody on the street would accept for it, because that's what they could get elsewhere.
Okay.
Anyways, okay. So now, if you look at this land patent, it says. Does given by these presents, does given grant unto said Santa Fe Pacific Railroad Company, successor in interest to Atlantic and Pacific Railroad Company and its successors, and assigns the tracts of land listed as aforesaid and described in the foregoing to have and to hold said tracts with the appurtenances thereof unto this railroad company to its successors, and assigns forever. Okay? There's nothing reserved. This is absolute title here. And here's where it's signed, right? And it you know, that's it. That's the whole land patent. If you read, that's it. Recent land patents are inside a box. That means they have no authority. The land says the land is granted to John Smith, his heirs, and/or assigns forever. If you look at this Arizona one, not that one. It must be still circulating.
Do you have it right there, maybe?
I'm sorry.
Yeah, this one. It says,
There's more box around that page, is there?
well, it says there is, yeah, it's hard to tell, it doesn't look like it. It says, said tracts, it says, now ye therefore that granted by the United States unto said claimant the tract of land described to have and to hold said tract of land with the appurtenances thereof unto said claimant to the heirs and assigns of said claimant forever. But then it says subject to any vested and accrued water rights for mining, agricultural, manufacturing. See, this one was granted in 1958, and so then they were reserving mineral rights and in this case water rights. You see what I'm saying? But the older ones don't say anything. Okay, they don't reserve anything. And this one here is an older one. This one here is issued in 1915. And notice also that all of the legal descriptions are spelled out. Okay? In other words, Township 18 North, Range 23 East. Okay? That's all spelled out. There's no Arabic numerals. Okay? It's all spelled out. And that's the proper way it's done at common law as well. So there's little things that are very subtle that you don't realize what's going on if you don't notice it.
If you was to buy some property that really didn't have the mineral rights, and you go back to the land patent, and it doesn't specify whenever you get it transferred that that's not, do you end up with the mineral rights?
You could essentially take the mineral rights, that's true.
That might be worth a small fortune right there.
What about this?
What about it?
That is on fire.
Well, it looks like it might be in a box, yeah.
What do you mean it might look like it's in it? It looks like it's in it.
Part of it is. Part of it is.
See, it's got a seal.
Part of it is. Well, the seal kind of breaks the box, that's true. But yeah, the part of it looks like it's in a box. Yeah. Well, it's international law again, and international law is de facto, but it's still, yeah, well, notaries, you know, when I was in notaries, a lot of them are in boxes. Although when I was in New York, and nothing is by mistake, I'm telling you, there's nothing that's by mistake. When I was in New York, I saw a lot of notary seals that were not in boxes. There's nothing that's by mistake.
It's recognized, obviously.
Oh yeah, of course. I mean, if push comes to shove, if you go in and make the right arguments, then they could say, well, there's nothing on this page. But, you know, I mean, if you want to defeat it and say that it's a fraud, you know, then you can do that. But, I mean, do you want to?
This is basically saying that it's documented anyway.
Right.
It's not, I mean, once it's documented by this seal, then it doesn't matter really probably what that box says, does it?
Yeah, I don't, you know, it's international law. They're doing that pursuant to the Hague Convention. That's international law. Any international law is de facto by definition because all of these governments are corporate governments. You see what I'm saying? Hague Convention. That's a convention between de facto corporations.
Right.
Okay? So what's that got to do with the de jure people? That's the reason the World Court dismissed the Republic of Texas case, because they don't have authority.
So if I box something in as a sovereign, then it has validity?
Well, my attitude, I would never box anything in as a sovereign, because I am de jure. I'm the king.
So that,
I don't want to take it off the page. I mean, unless you really want to take it off the page.
Well, if you sign something you really don't want to sign, if you put it in the box,
Yeah,
you
but-
really sign it.
Yeah, that's true. But having said that, if you're signing something that you don't want to sign, don't sign it. What are you signing it for? If you have to go and play these legal tricks, now you're going into the law of thieves, and you expect the thieves to honor your box?
I was thinking of something like where the police officers say, if you don't take the sign this, we're going to take you to jail.
I'd tell them, you go ahead and take me to jail, and you get that judge out of bed. I want to see him now. I don't care if it's 2 o'clock in the morning.
What was that about the $70,000 if they take you to jail and don't do that?
3 days. If you're in jail for 3 days, they get to collect $70,000. I'd tell them, you go ahead and take me to jail, and I want that judge, you get his butt out of bed.
Oh, he'll be happy.
Yeah, he will, you bet. You get him out of bed.
If you're in jail for 2 days, then you could...
I have no idea. Okay, so all Crown patents say that they reserve something. Actually, Crown patents are really bad. They reserve a lot of stuff, actually. But they still don't say anything about property taxes, and they don't say anything about easements or anything like that. No patents. I've never seen a patent that said anything about easements or anything like that. And they don't say anything about property taxes. They don't say anything about eminent domain. They don't say anything about zoning rules and regulations. None of them do. I've never seen one that said anything about that. Sometimes they reserve mineral rights, and sometimes they have other reservations. But you know, like that one there, that Arizona one reserved like water rights. You know, you're in the desert. You know, that's an issue. You know. Usufruct. This is Roman law. The right of enjoying all the advantages derivable from the use of something that belongs to another, as far as is compatible with the substance of the thing not being destroyed or injured. A usufruct is a type of a trust. Federal Reserve notes are promissory notes. Federal Reserve notes are commercial paper. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt of the United States, the validity of which is solemnly established by the 14th Amendment. When you pay for land with a banknote, it is not paid for, therefore a trust, a usufruct, is created. That's why the government has eminent domain. The government sold the land, by paying for the land with their commercial paper, you gave it back. It's exactly what happens. And plus what happens is they go and sell it, like if you look at that Crown patent, and this one here even. You know, all the railroads and the Texas ones, okay? What they do is they sell it, like this here was 10 miles, okay? They sold 10 miles worth of land on each side of the railroad to the railroads and that was the price they paid for putting in the railroads. And so they granted this land to the railroad company. So now the railroad company sells it. Whoever they sells it to gets a colorable title. And unless they understand what's happening and bring forward all the rights and privileges of the land patent, all they have is a colorable title, which is nothing. So it's quite a little scam they have going on.
Yeah, the whole thing.
Have you ever seen a road that goes along in a straight line, and when it comes to some guy's land, it turns and goes around the outside of the land to where it's going straight again? This is because all those landowners didn't really own the land except for the guy whose land they went around. They don't have eminent domain unless there's a colorable title. There's Spanish land grants in Arizona, huge tracts of land that are you go to look at any city planning office and stuff like that, and it'll show these Spanish land grants. They were granted to Spanish families before the Spanish-American War, before Mexico, when Mexico was part of Spain, and they're still there today. There was people I know in Arizona that told me. They said, we've had land in our family for generations, and we've never paid property taxes, and they don't even try to communicate with us. And we just pass it on from father to son in our family. And they've had it in their generations, in their family for generations. And that's how it's done, okay? You don't record it. You can, but who cares? Why do you need to record it? If it's going from me to my son, well, then my son just builds himself a house over there, and he lives on it, and then when I pass away, he just continues living on it, and who's going to dispute it? Mm-hmm. You see, he's always been there, and before he was there, I was there. See what I'm saying? So possession is, he has squatter's rights, essentially, after 7 years. I don't have to give him a quitclaim deed. He's got squatter's rights. I could give him a quitclaim deed, but it really doesn't matter, because after 7 years, he's got squatter's rights. Evidence of your usufruct. They call it real estate. You pay a yearly rent. They can take it away from you. If they can take it away from you, then you don't own it. Your land has easements. Your land is subject to zoning rules and regulations. If you pay for land with a promissory note, it creates a trust. The way you defeat the trust is you have to pay for the land with gold or silver coin. And you have to say it in a deed, because they can presume that you use commercial paper. Remember, it comes down to those presumptions again. How can you have true allodial title to land? You bring forward all the rights and privileges of the original land patent. You pay for your land with gold or silver coin. At common law, our numbers are all spelled out. In other words, it's 5, not the Arabic numeral 5. The number 5 is an Arabic numeral and in the matrix. Legal descriptions should be in metes and bounds. And so, this was in the first one that I did. And I still actually do this, and it's not fatal. At least nobody's challenged it. But technically, what I should have done is got a surveyor to go out and do a metes and bounds legal description, even on my land in Texas, in Arizona, because all of these pieces of property that I just used the legal description that they provided. In other words, this one here says Lot 104, Arizona Rancheros, Rancho 108. You see what I'm saying? And that's 1 acre. And so there's a plat that's in the county recorder's office that lays out this probably 160 acres or something into 1 acre lots. And it's one of them. And so technically what I should